Good morning, everybody. So welcome again to the article comment. And today we're going to review an article concerning JUTA Company LTD and orders versus the court and orders. Transfer Provincial Division, 1991. And here is the case. Where the subject matter of work is the same, caution should be exercised when assessing whether or not the one work constituted an infringement of copyrights of the orders. Fourth, there might be similarity and connection between the two works. A substantial part of the copyright work will not show to have been reproduced in other work where the alleged infringer and so that his work originated in a source other than the copyright work. The applicant have the copyright in a work entitled Silk on South African Income Tax. The first respondent and three other persons wrote a work entitled Income Tax in South Africa, with application alleged infringe the copyright. Thereafter, he and other persons began writing the second work also with title Income Tax in South Africa. And the third person, as their publisher began advertising work, at the same time, the second and third application were completing on 11 edition of their work. Or the applicant demanded that the author of the first work cease infringing the copyright in the other one. They also indicated their concern that the second work would also contain infringement of the copyright and demanded sign of the manuscript. The respondent did not admit that the first work had contained any infringement of copyright, but undertook that no new edition of the work would be published and affirmed that all existing stock had been destroyed. The respondent further denied that the second work contained any infringement of the applicant copyright, understood that it would not, and affirmed that it was intended as a new major test work and a practitioner other than student. So this case very important one and interesting to discuss. The applicant then applied for an interdict restraint. The respondent from infringed their copyright in the copyright work by inter alia publishing the work in South Africa. The applicant also saw an interdict restraining a respondent from competing unlawful with the application by inter alia publishing second work. The applicant alleged that the first work contained numerous similarities with the copyright work, including the use of non-standard term coined by the second and third applicant. A list of abbreviations in the copyright work table cases were copied directly in the first work, and there were other examples of passages in which the phraseology and punctuation were similar. The respondent's second work has published shortly before the answering affidavit were filed. In their replying affidavit, the applicant contended that the passages to which reference had been made as indicating copyright had been changed cosmetically in the second work. The respondent filed a second set of answering affidavit in response to this change and contended that the first work has based on lecture notes previously used by the first respondent at the University of the Witwatersrand, and all the work authored by a certain Van Nicker and attending copyright work. As far as the second work is concerned, the first respondent contended that it were based on sources other than the first work or with attended the work, in order to clarify some of the conclusion which arose from the apparent contradiction in response to set of answering affidavit. The oral evidence the first respondent will lead The effect of this evidence were that the first respondent's intention in writing the second work were to create a work different in character and objective from the first work, etc. One we could be on the use of more sophisticated reader than student, referred upon to the probability that most of the passages in the work to which the applicant had referred as evidence of copy originated in the first respondent lecture noted that alternated the copyright work, or in work by Van Niekerk, there were some passages in respect of which the first respondent could not identify their origin and for which the original manuscript were unobtainable. It's very interesting. So just see the case following. So what's happening now? In deciding whether or not there has been substantial copying, caution has to be exercised in applying the principle enunciated in the authority on copyright. For the subject matter of copyright work and the respondent work was the same, viz. The income tax law in South Africa, which there was governed by the provision of single act. It has also to be remembered that the object were to prevent the alleged infringer from availing himself of labor, order, and thought. The applicant had to show that the original work has the source from which the alleged infringed work was derived, that the applicant had made out a prima facie case to this effect were clear from the similarity which were apparent between the two works. In the absence of reply to applicant allegation regarding cosmetic changes to the second work, the applicant would have been entitled to relief. The allegation contained in the second set of answering affidavit, however, suggests that there had been no infringement of copyright after the hearing of oral evidence from the first respondent. It was clear that there were connections between the copyright work and the second work, but the effect of the evidence was to show that the passages in question were based on work which attended the copyright work. The fact that the origin of some of them could not be traced to such work was unsatisfactory. But it appears that the first respondents were not being untruthful in regard to them, and they were not in any event of significance as far as the determination of the matter were concerned. Some of similarity between the copyright work and the respondent first work could be explained by the fact of both them cited the same provision of Income Tax Act, even if had been copying of copyright work in their respect. The fact that the origin of both were in the same act so that the copying was in fact unsubstantial. Or the similarity could be explained by the fact that passenger in one work would have been the result of each author independent research. As far as similarity, such as the list of abbreviations were concerned, there were isolated instances which did not warrant the relief sought by the applicant. The fact that the respondent has undertaken not to publish the first work means that no useful purpose would in any event be served by granting any relief in respect of his work. The applicant were dismissed. So that's the case. So we have some comment. Following comment. According to the second applicant who received information in January 1989, which lead him to make a study of the affected work. This show he alleged revealed that the large and significant portion of affected work reproduced verbatim substantial part of the copyright work. So Many cases they use the word verbatim substantial part. In addition thereto, according to the second applicant portion of the affected work, we produce patches of the copyright work with relatively insignificant change of wording or by paraphrasing portion thereof. So the first and second, third applicant fear that a new work, one of whose co-author were also a co-author of the affected work, would likewise contain reproduction of substantial part of the copyright work. The applicant, through their attorney, sent letter of demand to the first, second, and third respondent, as well as to Merge, Prime, and Amsley call upon all these persons to give a written undertaking that the alleged infringement of applicant copyright would see to and would not be perpetrated again in future. The letter also called upon the addresses to deliver up the alleged infringing material and require undertaking add to the payment of compensation to the applicant. The attention of addresses were also drawn to the fact that applicants were concerned about the imminent publication of the new work and required a copy of manuscript thereof to enable the applicant to ascertain whether any work infringes the applicant copyright. So that's the case. So we normally see the case law discussion. Very interesting to discover. We have many case law concerns and problems. The applicant alleged that the copyright work is an original literary work and that they are the owner of the copyright. As such, they are entitled to term in section 6 of the Act to the exclusive right inter alia to reproduce the work in any manner or form, to publish the work and make an adaptation thereof, and to reproduce or publish any such adaptation. Reproduction is defined in section 1 of the Act to include inter alia a reproduction made from a reproduction of the original work, which section 1a provided any act done in relation to work shall include the doing of an act in relation to any substantial part of such work. The applicant alleged that both copyright work and affected work were duly published and required in terms of act. The question for determination is whether sufficient allegations are contained in the founding affidavit to indicate that a substantial part of the copyright work has been reproduced in affected work. So the reproduction of the substantial part denotes a qualitative rather than a quantitative standard. So that is the main point of the problems. Whether the copyright only focus on the quantitative, it's not even focus on the qualitative. So when this case they focus on the qualitative, so that's a problem. In Gallagher Publisher PT LTD Orders versus Erasmus, the appellate division adopted with approval following statement in the case of Labrook Football Ltd and William Hill Football Ltd. If he does copy, the question whether he has copied a substantial part depends much more on the quality than on the quantity of what he was taken. One test may be whether the part which he has taken is novel or striking, or is merely a commonplace arrangement of ordinary work of well-known data. Such may sometimes be convenient shortcut to ask whether the part taken could by itself be the subject of a copyright, but in my view, that's the only shortcut And a more correct approach is first to determine where the planted work as a whole is original and protected by copyright. And then to inquire whether the part taken by the dependent is substantial. All right. A wrong result can easily be reached if one begins by dissecting planted work and asking could section A be the subject of copyright if it's true by itself? Could section B be protected if it's true by itself, and so on? To my mind, it does not follow that because the fragment taken separately would not be copyright, therefore the whole cannot be. Indeed, it has often been recognized that if sufficient skill and judgment have been exercised in devising the arrangement of the whole work, that can be an important or even decisive element in deciding whether the work as a whole is protected by copyright. So we have also many cases here. The British court have not excluded the possibility that a single word can be a literary work and thus subject of copyright. That's a reason because if you can, when you copy a single word, there's in effect much to the market, and even they don't protect the title. So, you know, as a corporation and other source insurance consulting international LTD 1982 RPC, in this my view, there's no reason why chapter of the book or even pages, sentences and phrases staying content cannot be an appropriate case be regarded as separate distinct literary work enjoy copyright. See generally in this respect number on copyright 1999 edition page 215 Cornish, intellectual property page 348 Lahore, copyright law paraphrase Ladi Prescott and Victoria, modern law of copyright, Blackman, copyright law 5th edition. The principle to be applied in this succinctly stated in OSD Handbook of South African Copyright Law, whether the learned authors at page 120 state the following. Section 128 of the Act provides that any reference to the doing of an act in relation to a work means a reference to doing that act in relation to any substantial part of such work, which is consistent with the test for infringement being primarily qualitative and not quantitative in nature, as long as it was taken as substance in the original work and is not de minimis or has sufficient fit to constitute the embodiment of original intellectual activity in material form, for instance, a paragraph in the book, or perhaps even a sentence, a sequence of sentences. Copyright infringement would arise. Support for this contention can be found, for instance, in S12 of the Act, which postulated that the taking of an original quotation from a work can constitute copyright infringing if the state formal conditions are not met. When determining whether the taking of paragraph of sentences constitute copyright infringement, one must have regard to the degree of similarity between original material and derivative material. So this case cover oral nature and the problems of copyright, whether they don't really focus on the content of the work, but they will consider the content of the work itself too. You are listening to the radio of NIIPC reported by Nguyễn Thái Cường from Institute of Intellectual Property and Competition, 27 October 2021. And now we come back to the case. This form basic for further allegation is replying of the Davis for the fact that respondents have reproduced and adapted substantial part of the copyright work in writing, printing and publishing the new work and selling copy thereof. Thereby, so she alleged for respondent have infringed the applicant copyright in copyright work. It must be borne in mind, in my view, that the first respondent himself made reference to the new work in his answer affidavit, compare the work with affected work, and make the allegation that as the new work had now been published, a comparison would reveal that it does not contain any reproduction of substantial part of the copyright work. To this extent, the replying affidavit and dealing with allegation making the answering affidavit and the alleged new matter is not really such in any event to the extent that the allegation do constitute new matter, then there is the fact that the new work make its appearance only subsequent to the launching of the application. So, see on the case following. In any event, the extent that the allegation do constitute new matter, there is the fact that the new work make it appearing only subsequent to the launching of the application. Prior thereto, applicant had requested that manuscript of the new work as it exists in February 1989. And there is nothing to suggest that no manuscript existed as that date. Indeed, the fact that a respondent stated that work was still in the process of being written indicated that a portion of manuscript must have been in exercise, but the respondent had consistently refused to allow the applicant to have signed thereof. The applicant has also indicated make out a prima facie case in regard to respondable apprehension that the new work could contain material which infringed the copyright in copyright work. Moreover, I consider that phrase 3 of the notice motion is couched in wide enough term to cover infringement of copyright new work in light hereof the principal track in Circle Investment, PT, LTD, Town Council of Borough of Stanton I consider applicable. So many arguments around how to define a substantial part of the work. It seems like a very long discussion. I hope that if you have time, just read through the case and and here also have a word cross-examination that really discuss about. I don't know, you listening to the case and you can see this work. It was subjected to research in cross-examination, traversing a wide spectrum, and I accept the authenticity of his statement that he was unwell and one stay during his evidence, which necessitated the postponement of the hearing of the day before he could resume his testimony. So again, it's very strong argument. My point. And that's all the case, and it's in common law. normally have very good argument. Yeah, and sometimes I think it's too long to read all of this, so just spend a few minutes to judge the case and to see how it's going. So we just make some circumstances. We go to the argument. All right. There remains a question whether any case has been made out in respect of the new work based on unlawful competition. It is apparent from what has been already said in relation to the affected work that the applicant cannot rely on infringement of copyright to substantiate any such case. However, it will argue that there has also been unlawful competition in representing the new work to be a new major tax work. The first contention advanced by the applicant that it is but a second edition of the affected work is, to my mind, void of substance. It is work two volumes. The first volume comprising well over 1,000 pages, and the second approximately that number of pages that compared to the single volume of 600 pages. The first volume comprised tax, which the second contained Income Tax Act. The regulation promulgated there under double tax agreement with all country practice noted and an index. This volume is in loose leaf form. It is apparent that both in content and format is differ from the affected work. The second contention is, in my view, equally without substance. It is submitted that as the first correspondent of his own evidence, hence make use of material from all the work, having obtained the copyright holder permission so to do. In creating a new work, the latter could not be described as a major tax work. I am unable to agree. The selection and arrangement of all that went into the new work were that of the first respondent, and also the combination of such material with its own input in order to create a whole, and the relief shall in respect of the new work must in my judgment thereof also be refused. There are many issues, of course. Yeah, it's what argue on behalf applicant that the allegation of plagiarism has been made again the first respondent, and the word of attorney and client costs were justified. And again, this consideration, that is the fact that applicant was confronted with passages in the factory work, which, in absence of any explanation, appear to constitute deliberate copying. Example, the list of abbreviation of decided cases. There were no admission of copying in the letter of undertaking to which I have referred. The procedure advertising of the new work create the impression that 2 pages of the affected work were reproduced verbatim there. In all circumstances, I consider that no special order in regard to the cost is warranted. The respondents are liable for the cost of the applicant to strike out, as well as the cost of the 2 days where the case was unable to proceed. One, because of the postponement sought by counsel to correct the position in regard to the update of the Van Nicker work, and the other due to the indisposition of first respondent. So that is all the case we have been discussed so far this morning, and I have you enjoy the case feel comfortable to read the case, and very easy again. Thank you. You are listening to the radio of NIIPC, National Institute of Intellectual Property and Competition, reported by Nguyễn Thái Cương, 27 October 2021 from Tallinn town. Thank you very much, and then see you in the next session.